All right, we've got this breaking news just coming into our newsroom right now. The Supreme Court has issued a ruling.
So another unanimous ruling from the Supreme Court.
Most significant case regarding the Second Amendment in more than a decade.
Now, this is the most significant Second Amendment ruling in more than a decade.
Picture this. You wake up tomorrow morning and discover that a piece of paper you've been forced to carry, renew, and pay for repeatedly throughout your adult life has suddenly become meaningless. Not just in your state, but everywhere across America. The bureaucratic gatekeepers who held power over your constitutional rights for over a century just lost their authority in a single devastating legal blow that nobody saw coming. This isn't science fiction. This is the new reality that's reshaping America right now, and the implications are so massive that even the government agencies who built this system are walking away from it. The billion-dollar empire that just crumbled overnight. Before we dive into the legal earthquake that's shaking the foundations of American gun law, let's talk about something that will make your blood boil: the money. There's been a hidden billion-dollar industry operating in plain sight, built entirely on turning your constitutional rights into a subscription service. From application fees to mandatory training courses, from renewal costs to administrative processing, this system has been extracting wealth from law-abiding Americans who just wanted to exercise their basic freedoms. But here's where it gets really interesting. That entire economic ecosystem just became legally vulnerable overnight. Revenue streams that states have depended on for decades are suddenly drying up. CCW instructors who built entire businesses around mandatory certification are watching their phone lines go silent. State databases that tracked millions of permit holders are losing their legal justification for existence. We're witnessing the collapse of a system that was never really about safety. It was about money and control, and both pillars just got kicked out from under it. The financial implications extend far beyond individual permit fees. States have built entire bureaucratic departments around processing, approving, and monitoring permit applications. Thousands of government jobs exist solely to manage a system that may no longer have constitutional legitimacy. When you follow the money trail, you discover that the permit system created its own institutional momentum, with powerful interests invested in maintaining the status quo regardless of constitutional considerations. The federal government's stunning betrayal. Here's where this story takes a turn that will leave you questioning everything you thought you knew about federal gun policy. The Department of Justice, the same federal agency that has historically fought tooth and nail against any expansion of Second Amendment rights, just threw in the towel. Not only did they refuse to challenge this legal development, but internal documents reveal they've been quietly preparing for this moment for months. Think about the psychological impact of this revelation. For decades, gun control advocates have operated under the assumption that federal power would back their restrictions. State legislators crafting increasingly creative gun control measures always had the comfort of knowing that federal enforcement agencies would support their efforts. That safety net just disappeared, and the implications are staggering. Internal memos that have surfaced in court filings show DOJ attorneys privately acknowledging that permit systems were legally fragile in the post-Bruen legal environment. This wasn't a surprise development. It was an anticipated outcome that federal lawyers have been preparing for. The question isn't whether this shift was predictable, but why it took so long for the legal system to catch up with constitutional reality. Even more shocking is the revelation that 15 states have joined amicus briefs supporting the elimination of permit requirements. We're not just talking about traditionally pro-gun states. This coalition includes jurisdictions that have historically been neutral or even hostile to gun rights expansion. When that many state governments unite behind a constitutional interpretation, it signals a fundamental shift in legal consensus that extends far beyond partisan politics. The enforcement chaos that's spreading like wildfire. Right now, across America, police departments and sheriff's offices are caught in a legal limbo that's creating unprecedented confusion in law enforcement. Some departments are still operating under old permit requirements, creating potential civil rights violations with every stop. Others have completely abandoned permit enforcement, leaving officers unsure about how to handle previously routine situations. The most fascinating aspect of this enforcement breakdown is how quickly it's spreading through law enforcement culture. Constitutional sheriffs in counties across Arizona, Georgia, and Idaho have publicly declared they will no longer enforce permit checks. This isn't just passive non-compliance, it's active resistance to a system they now view as constitutionally illegitimate. Local prosecutors are dropping charges related to permit violations en masse, not out of ideological sympathy, but out of fear of civil lawsuits. When prosecutors believe they can't defend their cases in federal court, the entire enforcement mechanism breaks down. We're seeing a rare moment where federal law, state policy, and local enforcement are openly clashing, with citizens caught in the middle of rapidly changing legal landscape. The psychological effect on law enforcement officers cannot be understated. Many enter the profession with clear understanding of their role in enforcing permit systems. Now they're being told that fundamental aspects of their training and daily procedures may have been constitutionally problematic all along. This creates cognitive dissonance that's rippling through police departments nationwide. The blue state panic that's just beginning. The states with the most aggressive gun control regimes are experiencing what can only be described as legislative panic. California, New York, and Illinois, the traditional laboratories for gun control experimentation, are scrambling to find legal workarounds that can survive constitutional scrutiny. The problem is, every creative solution they develop runs headfirst into the same constitutional barriers that just demolished their permit systems. California's May issue regime, which gave local authorities nearly unlimited discretion to deny carry permits, is now legally indefensible. New York's strict concealed carry system, already weakened by previous court decisions, has lost its remaining constitutional foundation. Illinois, still reeling from ongoing litigation over magazine bans, now faces a cascade of lawsuits targeting every aspect of their gun control framework. The speed of legal challenges is unprecedented. Lawsuits were filed within 24 hours of the key legal development, targeting not just permit requirements but training mandates, application processes, and renewal systems. Gun rights organizations that have been building legal strategies for years are now deploying them simultaneously across multiple jurisdictions. What's particularly striking is how rural sheriffs in blue states are refusing to enforce permit requirements, creating pockets of de facto constitutional carry within hostile political environments. This geographical fragmentation of enforcement creates a patchwork legal reality that's unsustainable in the long term. The historical moment that changes everything. We're witnessing a convergence of legal precedents that constitutional scholars will study for decades. This isn't just another incremental victory in an ongoing legal battle. It's the culmination of a 15-year legal strategy that began with individual rights recognition and has now reached logical completion with carry rights protection. The legal foundation was laid systematically. First, the recognition of individual gun rights in 2008. Then, the application of those rights to state governments in 2010, followed by the establishment of historical analysis standards in 2022. And now, the direct application of those standards to carry permits. Each decision built upon the previous one, creating an irreversible legal momentum that permit systems simply cannot survive. What makes this moment historically significant isn't just the legal outcome, but the unanimous nature of the judicial consensus. When the highest court in the land issues such decisive guidance, it sends a signal to every lower court in America about how to interpret similar cases. We've entered a new constitutional era where gun rights aren't subject to policy preferences or political considerations. They're guaranteed freedoms backed by clear judicial precedent. The psychological impact on the gun control movement cannot be overstated. For decades, they've operated under the assumption that they could outlast conservative court majorities or find creative legal workarounds to constitutional requirements. That strategy just became obsolete, and the movement is struggling to adapt to a legal environment where their fundamental assumptions no longer apply. The industry transformation that nobody expected. Beyond the legal and political implications, we're seeing a complete transformation of entire industries built around the permit system. Gun stores that specialized in permit processing are pivoting to different services. Training companies that built their business models around mandatory certification requirements are scrambling to find new value propositions. Even gun manufacturers are adjusting their marketing strategies to account for dramatically expanded carry rights. The ripple effects extend into unexpected areas. Insurance companies that offered specialized coverage for permit holders are reevaluating their products. Legal service providers who specialized in permit-related issues are shifting focus to other aspects of gun law. Technology companies that built software systems for permit tracking and renewal are looking for new markets. This industrial transformation reveals just how deeply embedded the permit system had become in American commerce. It wasn't just a legal requirement, it was an entire economic ecosystem that employed thousands of people and generated billions of dollars in economic activity. The speed with which this system is being dismantled demonstrates the powerful effect of constitutional clarity on established business models. The Counterrevolution strategy. Gun control organizations haven't given up. They're adapting their strategies to work within the new legal framework while attempting to preserve as much restriction as possible. Within hours of the key legal development, major anti-gun groups launched emergency fundraising campaigns and began crafting new legislative approaches designed to pass constitutional scrutiny. Their strategy involves expanding sensitive place designations to make most public areas off-limits to carry, implementing training requirements that function as de facto permits, and creating new bureaucratic hurdles that slow down the exercise of carry rights without technically requiring permits. The goal is to make constitutional carry practically meaningless while remaining technically compliant with court decisions. California and New York are leading this resistance effort, introducing legislation that classifies ever broader areas as sensitive zones where carry remains prohibited. The legal chess game involves finding ways to keep restrictions alive using public safety arguments, emergency powers, and creative interpretations of court guidance. However, legal experts predict that most of these workaround attempts will fail when challenged in federal court. The same constitutional principles that eliminated permit requirements also undermine many of the substitute restrictions that states are attempting to implement. The new America that's emerging. The transformation we're witnessing extends far beyond legal technicalities or policy changes. It represents a fundamental shift in the relationship between citizens and government regarding constitutional rights. For over a century, Americans have been conditioned to seek government permission for exercising basic freedoms. That psychological conditioning is being reversed in real time. States are moving with unprecedented speed to implement constitutional carry protections. Florida's governor has ordered the elimination of concealed carry permit requirements by year's end. Montana and Texas are expanding recognition of carry rights into previously restricted areas. Tennessee's Attorney General has issued statewide guidance declaring local permit requirements legally void. Perhaps most significantly, South Carolina and Alabama are considering state constitutional amendments that would lock in these protections regardless of future federal court composition. These states aren't just reacting to current legal developments, they're building long-term constitutional resilience that will survive political changes and judicial appointments. The speed of this transformation has caught even supporters by surprise. Nobody expected permit systems to become legally vulnerable this quickly or for the response to be this comprehensive. We're watching decades of accumulated gun control legislation get swept away by constitutional clarity, and the pace of change is accelerating rather than slowing down. This isn't just the end of permit requirements. It's the beginning of a new constitutional era, where government power over individual rights faces much higher legal barriers and much more aggressive judicial scrutiny. The America that's emerging from this legal transformation will look very different from the one that existed just months ago.